Good luck to you, sir. You can go back with the bailiff.
Okay.
Yes, sir.
I think Mr. Parker might be really good.
You're funny.
I'm getting there. Let's
I'm in
see.
no hurry, Judge. It's not like robust.
That's what he was saying earlier.
I probably don't want to know what you guys are saying. Herbert Kane, 24 DCCR 1083.
We were in county court 2 the other day, and it took literally 20 minutes for my literally 20 minutes. And I was doing rejection. He tried to say, I believe it. I'm gonna go get on Zoom and beat you. So I approached the judge after that plea. I said, by the way, Judge, Mr. Ross is on Zoom. He called his office to get on Zoom.
That's funny.
And he had to wait another hour.
All right, sir. Are you Herbert Kane? Is your name Herbert Kane?
Yes, ma'am.
And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Rapon. I've received that report dated August 13th of 2024. Dr. Rapon made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial. Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd of 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand what could happen if you go to trial and you're found guilty?
I understand, but can I ask you a question?
Sure.
If I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing, what happened surrounding this offense or what they charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't even get
Here's the thing. Well, here's the thing. The offer is I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand if you go to a jury, what your options are today and what your consequences could be if you go in front of a jury.
And Your Honor, I've discussed these facts that concerns he's had with Mr. Nichols and explained to him the situation after he's had it evaluated. I've again talked about the offer, and Mr. Nichols has remained steadfast on the offer that he's made previously, which is the offer today.
Okay.
Just so that you're aware, it's not his first offense. He was actually before you in 2018.
Okay.
So they think for
Burglary of a building, it sounds like.
the state jail felony was what
Mm-hmm.
it was dismissed.
I've gone over it.
Okay. So it doesn't appear that it was dismissed, but I just want to make sure now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I don't have a felony on my case as far as what she said.
Look, regardless of that doesn't change. Even if you had it, it doesn't change the punishment in this one. Okay. That can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide.
Mind if I ask her a question?
No, you cannot ask her a question.
I was trying to see if that was a felony or not.
It's a state jail felony. Burglary of a building is what,
Sorry.
Go ahead.
It was a felony conviction with county jail time, so he may misunderstand that he is already a convicted felon.
okay. So it sounds like you got a 1244, which means you got a state jail felony conviction but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time in the county jail. That's what the paperwork looks like.
So I got 1244A.
Mhm.
Okay, but from what I understood, it got dismissed.
It doesn't get, it did not get dismissed.
So 1244A is not reduced.
It's where you do your punishment in county jail. And I go over all of that with anyone who's in front of me. So I'm sure I did the same with you.
That's what I'm saying.
It's a state jail felony conviction, but we're going to stop talking about that because it doesn't matter right now.
I was attempting to find out because I ended up going to Judge Green Woods for like.
That's misdemeanor court.
Exactly, for the reduction of.
Listen, it doesn't matter. Whatever that prior is or is not, does not matter on this case right now. This case that you're charged with, second degree felony, assault on a peace officer. The district attorney's office has made an offer of 5 years. Take it or go to trial. The prior is not what is enhancing you. It's not changing this. The offer is what the offer is. Do you want it or do you want to let a jury decide?
How much back time?
Well-
How much time would I actually have to do?
I've discussed that with him this morning, Judge.
Okay.
He has approximately 100 days.
So
credit
hang
for
on a
time in
second.
jail.
You're asking me questions that your attorney has already gone over. Listen,
I didn't get
don't
a
talk
day.
up-
I was attempting
don't talk over me.
for school, so
Listen.
I'm trying to figure out.
Listen and don't talk for a minute because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk. She has figured out your time, how much credit you have. I don't know how much time. He doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence. You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you how much credit you have. But it's just eligibility for parole. We don't know when you're really going to make it. If you do, that's up to you and how you behave. I need to know if you want to take that or if you want to go to trial. So what do you want to do?
So can I ask you another question?
Sure.
So you said a quarter of it I'll be eligible for parole.
Mm-hmm.
But he said I have 100, you know what I'm saying, 100 days.
Yeah.
Back time. So
Okay.
I already did, what, like 6 months now, and I got 100 days back time.
So here's the thing. I went to law school because I'm not good at math. I have no idea. Well, do the math. I don't know. I mean, it's a quarter of 5 is
About a year and
3/4.
about a year and 3 months.
So you know.
I was trying to make sure. That's
Well,
all I was trying to
We're not here for a math test. Do you want to take the deal or do you not want to take the deal?
He asked me today, Judge, if he would get out if he took the deal. And I said you would not get out
No,
today.
you don't get out today. You got to go get your number and do all the stuff. Mr. Parker's answered all this. I got other stuff to do. Do you want to take the deal or do you not want to take the deal? It's not going to be on the table after today. If you reject this offer today, I'll set your case for trial and this offer will be off the table. I want to make sure you understand that as well. I don't accept plea agreements once I put your case on the trial docket. So what do you want to do?
You can take it to trial.
Okay. So we'll put your case. You understand that I'm not going to take this 5-year deal and it's not going to get any better after today. You understand that, right?
How could it not get better?
Because I'm telling you it's not going to get better. I'm not going to accept a plea agreement for less than 5 years after today because I don't play with my trial docket and just put cases on it. So somebody thinks, well, if I make it last a little longer, maybe I'll get a better deal later. This is your deal today. If you don't want this deal, that's fine. It's either going to have a jury decide, which is fine, or the deal is going to be higher, not lower. Do you understand? And I'm not doing this to just for everybody on the trial docket. If you want a jury to decide, fine. You want the 5 years? Take it today because after today, 5 years is gone. What you want to do?
Let's see. So you pretty much told me in so many words that you weren't going to allow me to beat my case.
No, I'm completely going to allow you to beat your case. If you want to take it to a jury, 100%, we're going to get it set for trial and you'll be up for trial in whenever the next available trial docket is, and a jury can decide if you're guilty or not. And if you're guilty, then they can sentence you to whatever they think is appropriate. So absolutely, I'm telling you that you can try to beat your case. I just want you to understand that if you think you're putting it on the trial docket to buy some time to get a better deal, and then you want to plead guilty later, that's not going to happen.
I'm saying if anything, he used excessive force, and it's not necessary. So
Well,
be retaliation for public service.
we're not negotiating. Mr. Kane, we're not negotiating. You and I aren't negotiating today. The negotiation's done. Do you want the 5 years or do you want a trial?
You say the trial will be within like a year?
I have no idea when it'll be. It'll be the initial, I mean, it just goes on the trial docket with everything else. And as soon as it comes up, if it's number one that day, it goes. It depends on how old the cases are. It depends if somebody's in custody. It depends what type of case it is. So I can't guarantee you when your trial will be. I would like to think it would be, but no, a year or less, but I can't for sure tell you that. We're doing really good with moving trials, do the best we can, but I can't tell you for sure when that would be.
Question, but one more question, and I'll let you know. On a burglary on a.
We're not going back to that. Just let me know. We're not. No,
This was that chain on the doors.
we're not going back to a burglary.
The witness here,
Okay. Do you want the deal on this one, or do you want to go to trial?
huh?
Do you want the deal on this one, or do you want to go to trial? We're not talking about the other case again.
What's it to do?
All right. I'll hold it while y'all go. You need to do the paperwork with Mr. Parker this morning, and then I'll take care of it in a few minutes.
If we're not guilty,
No, if you're not, no. If you plead not guilty, then you go to trial. You're either going to say you did it or you didn't do it.
Oh, I didn't do it.
If you didn't do it, then we're going to set your case for trial. So we're going to put your case on the trial docket. And so, Mr. Kane, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. If, with your permission, I can release him and I can appoint another attorney today who can start getting ready for trial a little quicker. Is that okay with you?
Could I ask Mr. Biller?
You're going to get who I give you.
I was just asking this was on that case.
You're going to get whoever is on next up on the list. So it's probably not going to be him. Okay. He's not on our list anymore. Yeah. All right. So do you want to keep Mr. Parker or can I give you another attorney?
I got another.
Okay. Mr. Parker's released. We'll give you another attorney. You can go back with the bailiff.
In this courtroom hearing, Herbert Kane appeared before the judge after previously being evaluated for competency to stand trial, and the court officially determined, based on a medical report, that he was competent to stand trial. Kane was charged with assault on a peace officer, a second-degree felony that carries a possible punishment of 2 to 20 years in prison if a jury finds him guilty. The judge explained the legal situation clearly. The prosecutor had offered Kane a plea deal of 5 years in prison, which he could either accept immediately or reject, and instead take the case to jury trial, where a jury would first decide if he was guilty and, if so, determine his sentence. Kane tried to discuss details about the case and his prior record, including confusion about an earlier state jail felony burglary conviction, but the judge repeatedly explained that those details were not relevant to the current decision about the plea offer. Kane also asked questions about how much time he might actually serve, including parole eligibility and the credit he had already earned for time spent in jail, but the judge clarified that no one could guarantee when he would actually be released because parole decisions depend on many factors such as prison behavior. The judge emphasized that the 5-year offer was only available that day and warned that if Kane rejected it and chose a jury trial, the deal would be removed permanently, meaning he would not be allowed to come back later and accept the same agreement. Kane became frustrated and suggested the judge was implying he could not win his case, but the judge corrected him and explained that he absolutely had the right to fight the case in front of a jury, though the risk would be much higher because a jury could sentence him to a longer prison term if convicted. After several attempts by the judge to get a clear answer, Kane ultimately rejected the 5-year plea deal and said he did not commit the crime, meaning the case wow.